Well, greetings, folks. Bill O'Leary here, coming to you in this video to answer the question, what is probate? And so you're going to learn three things in this video. One, yes, what is probate? What is that all about? Two, what are some of the important functions that probate can serve? And three, what are the two big problems that we see with probate? Quick introduction. Again, my name is Bill O'Leary. I'm an attorney focused exclusively on estate planning, wills, trusts, and estates, elder law, trust administration, and yes, probate. And my firm is in Jacksonville, Florida, and it's named Legacy Planning Law Group. So let's jump right in. What is probate? It's a legal process whereby a deceased person's estate is going to be administered. And yes, while somebody is appointed to handle sort of the day-to-day of it, it's ultimately overseen by the probate court, a judge. So what are some of the important functions that a probate can actually serve? One, it's a way to determine if there is a will, if that will that's being presented is authentic and valid. So imagine a situation where somebody comes forward and presents a will and says, hey, this is the last will of the deceased person. Are we just to accept that at face value and believe them? Shouldn't we at least test the validity of that purported last will? Well, of course we should. I mean, who's not to say that maybe that will that's being presented was subsequently revoked by the deceased person after it was put together, or maybe the deceased person did a new will that had the effect of overriding or superseding the previous will. So we get to the bottom of the deceased person's intent. Probate can also provide a process for identifying who the proper heirs are. So if there is a will and it's determined to be valid, it's important to read it to see who the beneficiaries are. Sometimes a deceased person may intentionally disinherit a family member, and we won't know that until the will is read and verified. And oh, by the way, if there's no will in place, then we turn to state law that will dictate who the estate heirs are. The law is called intestacy, and that lists who the heirs are in the absence of a will. And sometimes it gets tricky to determine who the intestate heirs are, especially if, let's say, a child of the deceased died before the deceased person died, predeceased. Probate is going to lay out the ground rules for who gets what and in what amounts. Probate also can figure out what the deceased person's assets are. So as part of a probate, an executor gets appointed very early on in the process. By the way, we now call that executor a personal representative. We'll just use the term PR for short. One of the very first duties that a PR has is to what's called marshal the assets, figuring out what assets the deceased person had and where are they located, sort of get their arms around the assets. Probate can also serve the very important function of making sure the bills get paid first. Unpaid creditors of a deceased person are entitled to get paid before the heirs receive anything out of the estate. Again, if the claims are valid, and that's what the PR will figure out. So again, this is another very important duty. Pay the bills first. Now, how does the PR determine who the creditors are? Well, there are two types of creditors. One, that they need to be identified. The first are those creditors that are known. They are known with certainty the bill wasn't paid. There is another group called reasonably ascertainable creditors. They may not be precisely known, but they could be figured out with a minimal amount of looking through the deceased person's records to figure out their identity. These two types of creditors, those that are known and those that are reasonably ascertainable, are entitled to receive written notice of the probate case and then given 30 days to come forward with their claim for an unpaid bill. If they file it in 30 days, then that's considered timely filed. If they don't file in 30 days, they're out of luck. And even if they do file in 30 days, it's then up to the PR to determine, is this a valid claim? The second big type of creditor is somebody who's not known and somebody who's not reasonably ascertainable. This group has to receive notice as well. It's a different kind of notice. And even if the family might say, oh boy, we are 110% confident that our deceased loved one did not have any unpaid bills. Still, in order for the probate to complete its course, this group is entitled to notice. This kind of notice is not actual written notice, but it's what's called publication notice. So the PR has to publish a notice in a newspaper for 2 consecutive weeks and then let that sort of run its course for 3 months. If a creditor steps forward and files the claim, then it's timely, subject to being valid. If they don't file their claim within that 3-month period, they are out of luck. And finally, probate will provide a legal sort of mechanism for the orderly transfer of estate assets to the deceased person's heirs. Here's a question for you, by the way. If you die with a will, does your family still have to go through probate? After all, you have a will, right? Maybe you think probate is just for those deceased persons that die without a will. Is that the case? And the answer is no, that's not the case. Having a will does not avoid probate. In fact, in many situations, it almost guarantees probate. By the way, that's why having a living trust is often a much better solution than just having a will. But that's a talk for a different video. So what's the big deal about probate? There are 2 problems that we see. Number one, it takes a long time. And by the way, Florida is kind of notorious compared to other states, sort of known for having especially long and sort of protracted, difficult probate procedures. In my experience, the average length is 9 to 15 months. And talk to my probate paralegal. We've got plenty in the office right now that are longer than 15 months. So that's a period during which the estate is sort of frozen in time, and your loved ones can't get what you'd like them to get, maybe what they need to get. The second problem we see is that it's expensive, and by far the largest expense involves the fact that, well, at least in Florida now, an attorney must be involved in the probate case. The executor must hire the attorney. So the family can't do it themselves, even if they want to. And by the way, that same law sets the amount of the lawyer's fee to a percentage of the value of the estate, between 3 and 5% as a fee that goes to the lawyer. So it takes a long time and it's quite expensive. And that's why, as you might imagine, a good bit of the planning that we do at the front end is to help a client avoid probate and not stick their family in that mess. So if you'd like to know a little bit more about what probate is and maybe how we can help, we would love to talk to you. So we invite you to go ahead and take that first step in scheduling a free 15-minute phone call, what we call our discovery phone call. It's a chance for you to tell us what's on your mind, and then we can tell you if we can help you or not. Scheduling is very easy. Just go to our website, legacyplanninglawgroup.com, and there's a schedule your free call button there. You can also go to the bottom of this video. There's a link, might be easier than going to the website, and it takes you straight to our booking calendar. Pick the day and time that works for you. We would ask that you like this video as well. And hey, if you have not already subscribed to our YouTube channel, please do so. We are just creating more and more content and videos all the time. So Bill O'Leary signing off for now on behalf of everybody here at my firm. We call ourselves Team Legacy. Go make it a great day and a better world.